Managing the Employment Process. My name is Jen Beach, and I'm the Senior Operations Manager here at McMichael Insurance. Before we get started, I would like to address a couple of housekeeping issues. First, you'll notice that your cameras and microphones have been disabled for this webinar. We do have a chat feature, which is also disabled, but the Q&A feature is available for any questions you may have as we go through this webinar. So feel free to enter your questions as we go, and we will get to those as soon as we can. For your convenience, this webinar is being recorded and will be emailed to you once the recording has been finalized. We also have some additional reference material that we will email out to you at the conclusion of today's webinar. So without further ado, I am going to pass things over to Gerald McMichael, President of McMichael Insurance Agency, to get us started today. Gerald?
Thank you, Jen. Appreciate the introduction. I'm glad you've joined us. For those of you that I have not had the pleasure of meeting, please allow me to introduce myself. As Jen said, I'm the President of McMichael Insurance. My name is Gerald McMichael. Been doing this over 40 years now. I also got to say, this is as close as I get to actually wearing a tie. It's strung around my neck, but since Greg is on the call and he was in trial earlier today, he's got a tie on, so I thought I might as well up the ante a little bit. Thanks, Greg. So yes, this is our Value Beyond Insurance webinar series. Our topic for the day is managing the employment process. If you have employees that you hire with the intent that they drive company vehicles, there is a section in here of particular interest to you on motor vehicle reports being used for screening purposes. So Greg's going to dive into that. McMichael Insurance started nearly 50 years ago as a family-owned insurance agency, and we're still family-owned. We extend the same hospitality and family feel that are to our staff and to our clients. The agency has expanded to provide insurance services nationwide, serving both personal and commercial insurance clients. We are viewed from inside the industry as a thought leader and an expert in coverage application and interpretation, and as a provider of expert solutions and superior services by the business community. We do have a couple of sponsors on this call today. National Tooling and Machining Association is one of them, and the other one is Excelis IT. National Tooling NTMA, if I can throw out the acronym, is an organization representing the custom precision machining and manufacturing industry. Since 1943, they have nearly 1,200 members nationwide and support the manufacturing industry through local chapter support, workforce development, advocacy, and discount buying power to their members. Welcome, NTMA members. Sorry, for you that are members, that comes easy. That's a little tough. It's a mouthful. Excelis provides network security and managed technology solutions nationwide. Being in the insurance business and a provider of high quality A+ cyber risk insurance, I tell all my clients, insurance should be seen as your last line of defense. Most importantly, though, what everybody needs is a good frontline defense. And I've had those panic calls from my clients on a Monday morning. Gerald, the FBI's here. They've locked up my data. The cyber scammers got into my system, locked up my data, and they're putting out a ransomware for $400,000. And unless I pay them, I can't access my data. My clients need me. Well, that's where Excelis IT comes into play. They provide that frontline defense to keep cyber criminals out of your backfield. Let's do the heavy blocking and tackling for your business. I want to welcome Excelis customers to this call. Let me say a little bit about Greg Meehan. We have a great relationship with Greg and his firm, GRSM. They are in a class of their own. Greg has served our clients very well. Some of his achievements personally are being noted as super lawyer status, and that is a real thing. Also, lawyer of distinction status, as well as being designated as a Michigan top lawyer. Greg did attend Michigan State University, but he also received some training at the University of Toledo, where he received his Juris Doctorate degree. So I'm glad we got some Ohio in there, Greg. I'm going to turn this over to Greg at this moment, and we'll say more about services he has done for some of our clients on the back end of this presentation. So with that said, Greg, if you can pop on the screen, and I'll leave and exit stage left for now.
Hey, good afternoon, everybody. Greg Meehan here. Looking forward to spending the next 45, 50 minutes with you on some important issues. But before we begin, I want to give you guys an incentive. I'm going to tell you a joke and type in the answer to the joke that you believe the proper answer is. I'll tell you at the end of the presentation what the answer is. And those that get the joke correct will be entitled to a $50 Visa gift card. I like to do that. It just makes everybody excited and gives you at least a reason for why at the end of the presentation your butt may be a little bit numb from sitting that long. So the joke is, what's the difference between a lawyer? I'm sorry, what's the difference between a lawyer on a motorcycle and a vacuum cleaner? Now, don't look it up on Google. But if you'd be honest and transparent enough, if you could tell me the difference between a lawyer on a motorcycle and a vacuum cleaner, and then we'll get to that at the end of the process. Let's go to the first slide for a moment, if you don't mind. So one of the things that I'm going to do is give you kind of a summary of what we're going to try to do. Next slide, please. We're going to talk about how to hire, fire, discipline, and terminate. And this is such an important process because first rule of law is that you hire slow, fire fast. And I know reality is quite the opposite today in the world where you can't find competent people to work. We're just hiring warm bodies and then we try to fire as quickly as we can. The problem with that is, as you're going to see with the laws as they are situated, the cost of a time of 60 to 70 hours over a year of your time defending a lawsuit and the expense of $70 to $150,000 in being impatient or not following some processes really is not cost effective. The time studies that I've done over the 5 years have shown that better to pay overtime and find the right candidate than put the wrong candidate in because the cost to remove them is so huge. One of the employment protection issues, and I just want to throw this out here, my goal is not to make you a lawyer at the end of this presentation, but at least to know what questions to ask, is the NLRB, National Labor Relations Board, whether you're a union or not, does apply to non-union companies as it relates to Section 7 and 8 of the National Labor Relations Act, which empowers employees to talk about the terms and conditions of their employment with others, and even talk in a pejorative manner about the employer that they work for, as long as it is tied into the terms and conditions of their employment. And one of those concerns we have is there's been a number of cases where recently there was one involving a restaurant where the guy got on a Facebook post and said, I work for this restaurant company, a well-known Mexican product company. And the salad we sell for $17, I went to Whole Foods and bought it for $6.50. I feel so terrible about the company I work for. They're not honest, et cetera, et cetera. When the company found this out, they immediately terminated the guy, required him to remove the Facebook post on the threat of all sorts of actions. The long story short, by the time the NLRB got done with this restaurant, this guy had hundreds of thousands of dollars in his pocket, along with enough money to pay for cars, a house, and some other things that he was trying to do while he was employed at this organization. So we have to be very careful about knowing that when an employee, in the old days, when an employee didn't like working for you and they spat out comments that were not necessarily positive for the company, positive for your customers, or positive about your competitors, you let them go. Today, if you do that, it becomes Section 7 and Section 8 problem that the NLRB, in my view, is at the bottom of the list, or what I call evil number one. They are the most aggressive, least likely, or least liked company or entity in the federal government from the standpoint of employers. And if you look at their mission statement, they really don't care much about protecting employers or helping employers. In my personal view, they're more about making sure employees have the right to engage in the activities that they feel appropriate. Next slide, please. The other big issue that's right now going on today is employee protection issues, drug testing. And we talked last time, some of you may have been in part of a presentation I did dealing with marijuana, recreational, and medical, and the whole drug testing process. OSHA has set in on this drug testing process and kind of expanded a little bit more. We know that the only area of drug testing that hasn't been impacted in the last 5 years in the changes of the law or the way that it's looked is the way over the road DOT drivers are. When the federal government gets involved, it's usually pretty straightforward, or when the state workers' compensation departments get involved in terms of accidents, drug testing is important. And in many states, if you test positive, even in marijuana, and get into an accident in a vehicle, it is a preclusion to any workers' comp benefits. And one that I saw and am seeing in the last 40 days, I've had 61 phone calls from clients across the country where we have drivers all of a sudden deciding that they need to have their service dog, quote, ride with them in company vehicles. There's a big issue going on across the country. What's a service dog? What's an emotional support animal? You probably had heard 3 or 4 years ago, the airlines went through that same process where people were bringing pigs and other sorts of animals as emotional support, and the backlash that have occurred. So drug testing, pre-employment, post-accidents for truckers and people with enhanced chauffeur driver's license is a hotbed issue in the litigation world today. And again, just in 30 days, we're seeing a bevy of truck drivers requesting the ability to bring their dogs with them as, quote, service animals. And again, distinguishing between a service animal and emotional support animal is difficult because there are paper mills on the internet that will give you a service animal certification. And it's just a very dangerous process when you start asking those questions. Next one, please. Employee protection issues, you know, we got driver's license history reports and hiring, and the view by the EEOC, and we'll talk more about this, is that like criminal record issues, driver's license record issues, and credit records can be used in a discriminatory manner to prohibit certain groups of people, minorities, genders, and others from being able to get into the workplace because of prior history. We've got camera in the vehicles today as one of the most important tools employers can use. But again, notifications of what an employer must give to the employee in terms of the use and how that camera cannot be altered. Some of you are aware that in June of last year, we had the new Pregnant Workers Fairness Act of 2023 came into play, which kind of added an additional law. We had Title VII, the ADA, and now we have the Pregnant Workers Fairness Act, all focusing in some part on accommodating a pregnant employee. And we're seeing this in certain areas where we have over-the-road drivers that are female, that are pregnant, and certain modifications that are being required in the vehicles. But we'll talk a little bit more about that at the end. And then this emerging battle between religious protections and employment. And I'll just be brief on this, and then we'll get into the fun part of how do you hire somebody and how do you fire them. One of the things that is crazy that has happened is that 10 years ago, 5 years ago, 3 years ago, we went through and still are going through in many places this whole idea of using him, he, she, they, it, non-binary, whatever the pronouns that an individual wanted to use. It was their preference to use it regardless of whether or not that matched up with their personal biology or their personal sex at the time of birth. And employers were compelled by the EEOC to give the right to the employees to basically be called who they want to be called and to reference the pronouns that they want to reference. And in the last year and a half, we've seen now a battle where certain employees who claim a religious preference, a religious belief that won't call a female by birth who now wants to be called a male because of a sex change or transgendering over, won't call that person a female name because that person is doing things that violates their religious practices, and calling someone what they're not has been deemed to be a violation of their religious practices. I'm not kidding you, people. It's crazy out there. And what the courts have done have basically stood up and said, we've got the battle between the First Amendment of wanting to be protected by religion, free speech, and we've got the religious protections. And what the courts have sided with, of course, is they've just abused the employer when the employer didn't do it perfectly between trying to mediate between these two groups. So yes, employers, you have to get together and mediate between someone that wants to be called something that may be different than what their birthright or biology is, and a person who has a religious belief that they're not going to call them that. And you have to mediate that, and you have to interact with that. And then you have to come to a conclusion of how everyone is going to be happy. And if you can find that you found that, great, things move forward and everybody works. If you can't find that's the case because one or the other sticks very tightly, then you end up firing them both or firing one. And then again, where does the lawsuit come back on? It comes back on the employer. And our federal courts have done very little to assist in guiding you on this issue. I just want you to be aware of that. We also have had some cases recently where people have shown up for job interviews and their job application says Don, but they show up in a dress and they want to be called Danielle or Denise or Debbie. And again, you're caught in that interview process in a situation you never expected to. Some of these are set up, some of these are true nature of the beast of employment law. Next slide, please. All right. The other big issue is offers of employment. I can't tell everybody more strongly that anytime you do an offer of employment to anybody, you must make it contingent upon many of these things. And I can provide you the draft form letter to use, but every offer of employment must be conditioned so that you have the option, once you find out the things you need to find out, as to whether or not you want to move forward. It must be conditioned on drug testing, on background search, on references and prior employers. Now, background search is normally referenced as a civil or criminal search, and normally it's only limited to criminal, but I'm telling you, you should be doing civil searches also. It would be good to know that you're hiring someone that had been fired 5 times before and sued sued 3 times before because he or she has been sued for sexual harassment. I mean, in fact, engaging in that. You want to do references. Now, of course, you're not going to get a lot of information from them, but you want to, and then you want to do prior employers. These offers of employment, if they are conditioned, you can start the people and then remove them when the conditions are not met, or you can hold them off until the conditions are met. But regardless, give yourself the tool to be able to do this right. Next stage, please. All right, we're going to start with, in every employment setting, this is the fun part for me, is the application. And 98% of what you're going to hear in the next 40 minutes from me are basic things that you have heard about, thought about, done, but may not have thought them in the context of how do I get the best employee that I can with the most greatest likelihood that that employee will be productive and long-term. Because the big issue that we find today is there's a lot of money invested in bringing people on board. And if you keep on bringing them on board because they're going out the door, or they're bringing lawsuits, or you're dealing with ADA, FMLA, and all other sorts of issues, it just makes it almost impossible for you to actually manage a productive business. And so the first thing that's most important of all is you've got to make sure everybody signs an application for employment. And many of you may bypass it by taking resumes. I'm telling you, I don't care if they're applying for the CFO or the CEO, all the way down to a line worker, sign the application form. Make that a mandate for them to do so. Why? There's a number of reasons. First and foremost, there's a doctrine in the law called after acquired evidence, and I'm about ready to use that after acquired evidence to defeat, in another case in Tennessee, an Americans with Disability Act claim where my client fired a guy because he had seizures and wasn't able to act in the appropriate manner as a prison guard. And we find out in his job application and in his medical form, he marked the box, never had these issues, never took medication, when we found out later that he's been doing this since 1990. We get to terminate his entire lawsuit based upon the lie that was made at the time of the application process, regardless of how discriminatory my client actually may have been. So that application gives you that potential ability. Number two, you lock the employee in the story. Number three, it allows you to take a brief look as to whether or not this employee is worth going to the second stage. And number four, what the application does is it allows you to look at the whole document, and you're going to see something. You're going to see it's completely filled out or it's not completely filled out. And if it's not completely filled out in today's world, that should be a red light that goes on, or a kick in the gut for you. Because if someone doesn't take the time to fill out the application in its fullest form, then I like to quote a movie that I enjoyed, the Forrest Gump movie. That's when you as an employer should run, Forrest, run. Because that employee who either is not completing that application, it's two reasons. They're either incompetent or they are trying to hide something. But you shouldn't care what the reason is. You don't want to invest all of your resources in bringing someone on that may be very good at manipulating a situation, only to find out that they don't have the attention to detail. That's why they didn't fill it out, competency, or they're hiding all of these other issues that go on. So the application process, even if you don't really care what's in it, if you look at it and it's not complete, this should be the first red flag that tells you I don't want to go to step two. Because if I go to step two, I already know that this is a problem. It's kind of like going out on a date, and pardon me if I have to use this as an analogy. You go on a date and the person that you are at that dinner table with, they are going to be the best that they ever will be and are at that date. Everybody's hair is nice. Everybody is showered, is clean, used deodorant. All right. It only goes down from that point on in the dating world and marriage. And I'm saying that with a little bit of a laugh and joke. But there's some truth to that. Same thing with the employment applications. They are not going to get any better than at the time that they filled out that application. And if you think you're going to prop them up to make them do more and extend beyond themselves, you're looking for the Tom Brady's of the world or the Patrick Mahomes if you're football fans, and they just aren't enough of them there. So the application in its completion and the way it is so important, if for no other reason than to make sure that this person is putting the time in to fill out the information for you. Now, there is called the ban the box. There are a number of states that do ban the box about asking for criminal background information. Those states are quite numerous that do have that. Give me a call if you are needing to have your application looked at. It's not a cost to you, but we'll review it. But some states we have to remove the ban the box issue. In some states, we also have to remove any kind of application that talks about salary in that regard. Just be mindful that you may be in a state that bans the box. Some of the states that do, just quickly, is Illinois, Minnesota, Louisiana, New Mexico, California, Oregon, Washington, Colorado, Maine, Massachusetts, Connecticut, New Jersey, and Maryland. Now, that doesn't mean you don't get to find out the criminal history later on. It just means as part of the application in those states, they aren't compelled and cannot be compelled to provide the information of whether or not they've got a felony or a misdemeanor in their background. All right, next slide. So we can assume that we get through the application process. So the next step is the interview, right? And I know a lot of people are doing interviews by Zoom. Some of them are still doing them in person. I strongly suggest, as best you can, to do them in person, because there is so much learned that's not said, but doesn't matter. It's good enough if you can see the person and see how they act. Of course, in the interview process, you want to watch how the person comes in. You want to watch if they're timely. You want to see how they're dressed. You want to see if their shoes are tied, if they're wearing socks, all of the stuff that allows you to get a better understanding of it. One of the things that I have a problem with employers when they do the interview is, first of all, they fail to ask every employee, do you have a non-compete or non-solicitation agreement? You want to know that as soon as you can at the beginning of the interview, because if they do, you want to get a copy of it. You may be prohibited from hiring them. And if you move beyond that and you ultimately do hire them, and then it shows up that they do, then you've just gotten yourself, the company, and the employee sued. And the damages can be quite substantial on top of the attorney fee cost and everything else. So in your interview, you're going to talk about or ask non-compete, non-solicitations. Do you have those? The other thing that's important in the interview, in a sense of seeing the individual and then finding out if they have a non-compete, is how do you qualify them? Now, there's an easy way to qualify them, and there's what I consider to be the bad way. And with all due respect, if you happen to do it the bad way that I say is bad, you don't have to follow my direction, but listen to me for a moment and maybe you'll see what I mean. The easiest way to qualify someone is not to ask them about their disability, if they have any, or ask them about their history or all of that, but let's get them talking. So give them the job description. Got to make sure your job description is appropriate, right? But give them the job description. And then this way, if you do something that they don't do, and that is if you take action, sorry about that, my phone rang there. If you do less talking, more listening by going through the job description manner, which all of us violate the law, in my view, or violate the process. We all like to hear ourselves talk, me including, and many times we don't give the applicant an opportunity to do so. But if you give them that job description and then you just start at the top, the job says you need to do this. What you do is you ask them, can you do this? What, when, how, where? Then you go down to the next one. Can you do this? What, when, how, there? Go to the next one, go to the next one. You go through the whole job description, and all you're doing is sitting back, watching them and asking them what, where, why, how, where. And what you will find is incredible, incredible, incredible information. And you will get them into a comfort level that I've actually had people near the end of the discussion with the job description part. They've actually leaned back and put their feet up at home on a desk, or in my office, they put their feet up on a little table. They've gotten so informally comfortable that their language sets down to where it normally is. The swear words start to come out, and the reality of the person. I had an individual indicate, yeah, I can do this job, but I really hated working in the administrative offices because I actually don't like working for women. And I had a woman say the same thing. I don't like working for my sex. They're blah, 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 blah. I've had guys say, yeah, I won't work in administrative offices, but this is what I've done. But it's so difficult because I get turned on, and I sometimes date the people I work with. And you didn't have to ask any of that. You just got them in the very comfortable situation so that your gut is churning. Is this someone I want to work with and fits well with us? Because people, at the end of the day, that's the only decision is, are they qualified, and do I want to work with them, and do they fit with us? Those are the three things that this whole process is designed to figure out. And if you let that candidate talk, the incredible stuff that they will say to you is unbelievable. By just saying, have you done this? With whom? Why? Where? How? What issues have you come up about? Then when you've got that all done, I only ask 5 questions, and I would suggest you only ask 5 questions also. First question is, of course, do you have any non-competes and non-solicitations that I need to worry about? No. Second question I ask them is, how did you hear about us? I've had people say, because they're already relaxed earlier, right? Well, I'm only really applying for it because to get unemployment benefits, I have to show that I've made an effort. Okay, well, you don't want that person there. Or I saw that you guys have this benefit, and I'm really looking for these kinds of benefits because these are the things that I want to do. These are the things that I'm going to do. Again, that is an important piece of information for you that you never would have learned. And if you've got a job where you need somebody to be there for the first 2 years of the most important project, that person wanting to get surgery scheduled in 2 months or 3 months, or wanting to get pregnant, or wanting to have extended vacation time, or all of these things, plays a role in the level of frustration and fit that you want to have. But those are kinds of questions you can't ask. But there are types of questions that you can get them to tell you by putting them in the position of, why did you apply for here? The third question I ask them is, what do you know about us? Tell us everything you know. Many times people will say, well, I just looked here, or I didn't do here. You don't want to hire that person that put that little effort into determining where you are, who you are, and what you do. On the other hand, if the person says, I've read your websites, I've looked on Google and what people have thought of your company, I looked at the different jobs that I'm applying for, and what kinds of machines you use or don't use, what kind of vehicles you drive, etc. That's the kind of individual they put an effort in to determine whether or not you were a good fit for them, because you have to look at the job as one, hiring them to be part of your team the rest of their lives. And the only way to know that is to go through those 3 questions. The fourth question is a fun question, and it's a gut question that you're just going to watch. And I like to ask them, do you surround or organize your work life around your personal life, or do you organize your personal life around your work life? Now, the answer is not important. And by the way, I have this on a sheet that I can send to all of you. The answer to that question is not important. What is fun and important is watching them start with the idea of, oh, I got to sell myself as the best worker in the whole world, and my personal life is not important. And then when they hear that come out of their ears, they then circle back, oh, but personal life is important. and a work-life balance is important, et cetera, et cetera. And again, you're not looking for any specific type of information, but you're looking to see how they think and where they go and what they're about, and see that circle acquiring. Sometimes they're very straightforward and they say, you know, my personal life is important to me, and I'll fit work in, I'll do my job, but it's not the most important thing to me. And others will say it is the most important thing for me. What you are trying to do is get a gut reaction. Are you hiring a person, A, that their car breaks down at 5:30 Friday night? And is this the person that drives to the dealership that night or Saturday and drops it off and fills out the form so that on Monday morning, the dealership can be working on the car and then they found a way to get to work Monday morning? Or is this the person that says, oh, well, I'll get it to the dealership on Monday morning and call in that my car has gone down? Now, that may not be important to you and important to the job that you have, but for me, it makes a big difference between the type of person that you're looking for. And if the one that you're looking for is one that it's okay that they drop it off on Monday and they miss Monday, or if the job is the type that you really need them to be organized and drop it off on Friday and Saturday and are available to work on Monday because they found a way there, that will help you in your gut determine, is this the right person that we want? And then the last question I ask, typical question, you've all heard it, but if you've done everything well so far, you finally get to the point where you say to them, so tell me the worst behavior or negative thing about you that you would like to change. And I am not kidding you. The answers you will get when you've got them in a comfort level is incredible. They've said, I like to date people I work with. It's easier. I like to take breaks if I can. I like to do this. I like to do that. And I even had a guy say to me, I kid you not, I'm too honest and sincere with my employers. And one of the ladies that I was working with kind of jumped in and said, well, that's not a negative trait. And he said, ma'am, I don't give a crap what you think about what my negative trait is. I told you that. Now, he didn't use the word crap. He used the F word. And I laughed internally because that's what I was hoping the guy would say. She didn't know what to do with it because she had not been in that scenario before. I get yelled at every day, so it doesn't shock me. But what we were able to do with him is, well, number one, make it very clear this is a guy we didn't want to hire. This was the guy that always tells the supervisor he knows better than what the supervisor does in the job. The answers are incredible. They will never be the same, and you will just be astonished at the things that people say. But at the end of this interview, you will come to the gut conclusion along with what's on the application as to whether or not this guy is qualified, whether or not that this is someone you want to work with, and whether or not this is a good fit for the company. So during this interview, additional red flags will go up. And if these red flags go up, this is your avenue to run as fast as you can. Now, I'm also going to suggest to you that you keep notes of this interview. And again, if you ask for my notes, I'll give you this form that I use that have the 5 questions. And then on the bottom, it just says, do you recommend an offer? Do you not recommend an offer? And the answer that you're going to write there is, I recommend an offer because the person was on time, the person answered the questions, the person seemed to be interested, the person seemed to know about us, the person seemed to be qualified, et cetera, et cetera. And then you just flip that on the bottom if you're not going to hold them qualified, that the person did not show on time, did not do this, did not do that. Now, why this is important is because the statute of limitations for not hiring someone is 3 years. And we are seeing lawsuits come where we are finding numerous people who have criminal background issues, and we'll talk about the green factors in a moment, and others where they are claiming discriminatory hiring practices by the employer. And how are you going to ever remember 2 years ago why you decided not to hire Joe when in fact you just got your memory and maybe some notes, but probably not. This form you can pull out and then you read exactly why you went forward with or did not go forward with. And it is a killer of the lawsuit that the plaintiff will file. And we're seeing a ton of those. So now we've got the application and the interview. Next slide, please. Before we decide to give the offer or we give a conditional offer subject to these things, we want to do background checks. And the traditional is references, employers, criminal and civil. And I really, really suggest that you do a civil check. It's very easy to do. We can do it for you. Again, it's not a cost, but we go into the communities where the person has lived and we check with the district and circuit courts and superior courts there. And it's very easy. Many times it's computerized and their names will pop up. You just want to know whether this person is a problem walking in or not. From a civil perspective, your agency that you're using for your criminal background check will take care of that process. You also want to call the references, even though you know the references are just going to tell you the same great stuff. This person is great. You want to call them. And then you want to call prior employers. And the reason you want to call them is they're not going to tell you either anything, but they will do something depending upon how skilled the HR person that's on the other end of the line is. They will give you the answer you need to know. And that answer normally or question would be, okay, you can't tell me, you don't want to tell me. You can only just give me salary history and all of this stuff. Would you guys rehire him? Now, normally, a person who's not skilled would say, absolutely not. And you'll get some of those. Others, there'll be that pregnant pause. And then they'll say, I really can't tell you. The answer with the pregnant pause is the same answer as the one of, no, we wouldn't. Listen for that pregnant pause. There's a reason why that person is pausing before they just come out with the truth. Because if the truth, it's so easy to say, absolutely, we would. We'd like that person back, or absolutely, we wouldn't. It's the pregnant pause where they're trying to adhere to the employer's policy, and they're giving you a signal. Now, is it a proof of 100% certainty? Absolutely not. But does it factor into all of the things that you've done in this hiring process? Absolutely, where you go. And again, the reason why I do not want you to do criminal background checks on your own and any other background checks other than civil and criminal from the court systems is because I want to protect you from finding information out that you don't need to know. Please do not have someone get on Facebook or Google and look at this person up, because the moment you find something on them, whether it's that they've got cancer in their family, their mother just died, or their family has breast or colon or a prostate cancer, it's that is protected by GINA, and someone can then come after you and say, well, you took them all the way to this process, and the only thing that caused you not to hire them is this conception that they may not be around long, or they could increase your medical benefits more because of the child they have that has cancer, or a family member, or all of these things. You can't unring those bells. So let the experts in HR do the limited background checks that we talked about: references, employers, criminal, civil, and in the background. And that should be more than what you need to know. Next slide, please. Now, the last thing that I want to drill on the background checks, and then we're going to talk about segueing to, okay, we now got this employee, what do we do with him or her? And that is the green factors. The EEOC says that 1 in 6 employees that are Hispanic, 1 in 6 that are Black, 1 in 9 that are Hispanic, and 1 in 12, I believe the new statistics are, of white males, will all have some criminal background touch with the system. And therefore, the courts are now saying that if you deny an employee a job because of their prior criminal history, you better be able to establish 3 things. One is that it was not longer than 10 years. If it's longer than 10 years, considering that in the application process is suspect, and you'll get nailed. Number 2, look at what the job requires. that person to do. And number three, look at what the person's convicted of. So if we got a person within 5 years that's convicted of check forgery, and you're hiring them to work in the administrative offices where they may handle certain accounting functionalities and all of that, clearly you're within the 10 years, you're clearly within the job and the criminal conviction having similar issues that would make you concerned, then you can correctly deny that person a job and not be deemed to be discriminatory in the EEOC's eyes. On the other hand, if you have a guy 7 years ago that got drunk in college, car went off the sidewalk and ran over two people and was convicted for manslaughter, and now he's applying for a job to be a sales rep or an administrative office person or a receptionist or whatever that is, while you got within 10 years, there's nothing about what he did 7 years ago that has anything to do with the job duties that he's being asked to do. So in that circumstance, you're not able to hire, not able to deny the hiring of that person. And then the third, of course, is depending upon whether you've got federal contracts or state contracts that require certain people cannot work unless they have a certain license, or they have to have licensing requirements. That's a total different world, and you'll live within that world of whatever the state or federal law requires of them. But I want you to be mindful of the fact that these background checks that you're going to do is going to give you a lot of information, and you still have to look at these 3 green factors in determining which way to go about doing that. Okay, next slide, please. Conditional offers of employment. All offers must be conditioned on background checks, employer checks, reference checks, drug tests, completion of onboarding documents, and completion of certification of a non-compete. Try not to allow the person to begin work until this has been done. But again, I realize the world we're in today, I don't have any problem at all you putting them into work immediately upon giving them the offer, as long as this offer letter is there. There is no law and no court that has not upheld an employer's removal of the person from that job based upon failure of any one or more of these requirements. Next one, please. Now you've got an employer, and one of the most important things for those that are in HR are hearing is, of course, how does the manager and supervisor engage with the employees? And the most important thing that you can do as a manager and supervisor is stop talking to people about things that you are expecting corrective action to occur, and put it into a written form is something that is as simple as an oral written discipline. And by building up the oral written discipline, you're not taking any disciplinary action against them. But what you are doing is 2 very important things. You are first setting the expectations of the employee. You are second of all putting the employee on notice that improvement is required. And third, if you do the disciplinary action properly, you will generate better culture and better relationships than you would if you didn't do so. So for instance, when I do disciplines, I bring the person in and I explain to them, hey, I want you to know what you do affects me. These are the people I have to answer to. And I know that you have issues on your side. So tell me a little bit about the difficulties you experience. And then you have this baseline, and then you tell them, I'm giving you this oral discipline, not because you're a bad person or I want you to go away. I'm doing it because how could I expect you to do what I need you to do if I don't give you the expectation? So this is my way of showing you and demonstrating to you that I care enough and what I expect from you. And then they walk out saying, yeah, same old crap. But when you follow up a week later and ask them, hey, how's it going? Is there any training you need? Is there anything that you need at all? They look at you like you're weird. But then another month go by and you ask them if there's anything that's going on. How's it doing? I see that you're doing this better. I see everything's working better. You will have developed a disciplined process that is designed to embellish and create relationships, not destroy and cause them against us. It requires a lot of work, but I am telling you across the board, it has been the most effective way of keeping people at work. Now, second part is managers, if you get a complaint, and we're just going to use sexual harassment because it's easier. If you get a complaint, you cannot simply say, all right, I'll take care of it. I'll go talk with him. I'll make it go away, etc. What you have to do to comply with the federal and state law of engaging in what is called prompt and remedial measures is you have to say, Mary, thank you for bringing the complaint about Sue. I know it feels uncomfortable when this happens. I'm going to let HR know, and we're going to do an investigation so that we can figure out everything. We can make corrective measures, and we can make this a good environment for you and that person. 9 times out of 10, one will say, great. The other time, the person say, oh, wait a minute, that's not what I wanted. And that's the person that creates the most problem for you as an employer, because if you don't say to them, but Mary, it really doesn't matter. You made the complaint. We're going to go forward with this process, and we're going to determine what happened, and we're going to find out what we should be doing in our work environment to make this a safe environment for you or them. What that will happen is that if Mary is the type that gripes a lot, she'll stop making complaints, which is a positive thing for you. If Mary is the type that is truly harmed, but is afraid of what will happen, well, during the investigative process, you will be able to fix the environment, protect her from retaliatory type of activities, and ultimately, like spouses who get mad at each other weekly, if not daily, and some of us not, if not hourly, we manage to work it out. And that's what the investigative process will do. It will give you as an employer an opportunity to fix that problem specifically, but you also may see some others. So the investigative process goes like, view all witnesses, take good notes, examine the documents, maintain confidentiality if possible. But remember, no one can promise anybody that you talk to that their confidence will be held and not breached. The NLRA does not allow employers to compel people not to talk about the terms and conditions of their employment. You can say, I will do my best to keep this confidential, but I may have to respond. Quick turnaround from the investigation to any discipline is 3 short days. So if you do your investigation and find nothing really happened, then that's what you report back to Mary, and you will report back to the person who's alleged to have done something wrong, that you may have not violated this, but you know what? It does seem like maybe a poor decision or a poor comment. We gotta work together so you guys figure it out. On the other hand, if it's something that really could involve a cultural shift or change, you make that occur. And this way you stop big problems from becoming huge problems. And that's why the 3 days requires you to be able to do that. And then we put this in a report, we put this away. So later on, if the employee, like Mary, in typical scenario would say, you know what? I don't want to report it. And if the employer says, okay, that's fine, it'll work itself out. Mary's going back and writing a journal. I told Steve this happened. And then 6 months later, she's written every day, this continues, and Steve's done nothing. Despite the fact that Steve may be able to testify that Mary said she didn't need any help, Mary's going to testify that I told him he should have investigated it. And that's what the court's going to say. And now a case has been created by the inaction by the manager and supervisor and being set up by a conniving employee or an employee that just didn't know any better. But the problem is the courts don't care about the employee and what they do. They care about what the response is by the employer. And the average litigation cost of discrimination harassment cases is well over $250,000 and well over 60 to 70 hours of time that's spent by you. Let's go to the next slide, please.
Sure thing. And Greg, I just wanted to let you know, we have about 5 or so minutes left in our meeting.
Yep. The next slide is, let's assume that you're getting to the decision now that you want to terminate somebody. This is a checklist. I've provided to the team a bunch of different documents and this checklist also that you'll all get a copy of. But before anybody decides to terminate anybody, these are the questions you want to ask them. Timing between the rule violation and the discharge. What does the employee personnel file look like? If it's got nothing in there of disciplines and you're now going to terminate somebody, you're in trouble, right? So this tells you that to terminate, I need to go back and start documenting the actions and reasons for the termination. How have we treated other people doing the same violation? If we want to fire Joe, who's driving a truck because he's got the cell phone on, which is a violation of our policy, but we haven't done that for Pete or Steve, then we're going to be in a disparate treatment. Are there appropriate remedies other than discharge? Is the discharge retaliatory in any way? Review the reasons for the discharge, and is this a mutual aid or support? That's the section 7 and 8 thing. But this checklist will tell you what you don't have and what you need to have, okay? And then you'll fix it, and then we can terminate. Next slide, please. Do I have to provide a reason for termination? Yes. You always, when you're going to terminate, need to provide the reason for the termination so you can avoid the presumption that exists in the law today that if you don't provide the reason, then the reason must be somehow discriminatory or based on age, gender, sex, national origin, marital status, etc. Next slide, please. Memorialize the termination, yes. Tape record, never. Never tape record terminations. But your responses after a termination to the unemployment must be in line with your termination letter. Everything must be the same argument, same claim, same issues. Next slide, please. We've already done that. One more slide. All right, special concerns regarding truck drivers. As you know, many of our drivers were putting cameras in the vehicles, both for purposes of protection of the company and compliance with the law. We need to have recent rulings have occurred where they basically have indicated that without the policies and procedures and the acknowledgements in place, the cameras could be a violation of a person's privacy rights. So we want to have all of that there. If we don't have the documentation, notification, and acknowledgement and acceptance of that, and a clear disciplinary policy of what happens when a person engages in that process, then we're going to be in trouble. So if we've got cameras in there, we need to do so. We also need to have strong policies of what is accepted within our random drug testing and our reasonable suspicion. One of the documents I have for you that will be sent out is a reasonable suspicion checklist. How do you go about in today's world of determining whether a person is reasonably under the influence to require a drug test? And this form I have that you just check the boxes, that will then be something that you'll be able to show to a court as to the basis for what's doing so. And more importantly, when we have truck drivers that are driving and there is an accident, by having the cameras, the strong policies, the reasonable suspicion procedures, and the strong policies about what is or was not accepted, we have found that those have been very important in kicking out almost every punitive damage claim that's been brought against a driver and a company where the employer has a policy and the employee violated, whether that's drinking on the job, whether that's using the vehicle after hours, and then there's an accident and someone is dead. If you've got the policies and you've got the cameras and you've got the processes and you're monitoring them and you're doing the background, it eliminates that liability. And if it doesn't, it at least eliminates the treble or liquidated damages that we've seen over and over again. Let's go one more slide, please, and then that's the thank you. So look, we jumped on a lot. I'm going to keep myself quiet from the standpoint of providing any more content. There's a lot that we can unpack individually with you on this. You just have to give the team a call and we'll set up a basis to do so. I really can't emphasize enough, though, how I would really want to get into your policies specifically over the road drivers, chauffeur drivers, and general back and forth people who use company vehicles, and where those policies need to be, because they are the only defense we have to those tragic incidents and accidents that occur, whether it's distracted driving, whether it's alcohol, whether it's marijuana, or whether it's a service dog that jumps up and gets into the way and causes an accident. The employer can only survive in that situation by having those policies. And by the way, you know, you will have insurance, of course, but there are a number of lawsuits that I've defended where the verdict was beyond the insurance amount, and that beyond the insurance amount then goes directly at the company. So some of these things can be life-ending for certain companies and responsibilities. With that said, thank you, everyone. And I can't say enough about how fun this is to engage with you guys. And I will look, the answer to the question is on a vacuum cleaner and a lawyer on a motorcycle. On a vacuum cleaner, the dirt bag's on the inside. So no matter how many of you guys have written that down, we'll get out the gift cards to you guys. I just may have to get a loan if there's a number of you that have gotten the right answer. Thank you, everyone.
Thank you, Greg. Let me just wrap up with a couple comments. Obviously, who you hire can make or break the future of your business. As an added benefit to the clients of McMichael Insurance, we make the services of Attorney Meehan available to our clients at no cost. That's right. His services have been totally underwritten and are available to the clients of McMichael Insurance at no cost. So I do get calls almost weekly from clients asking me legal questions. Just a few days ago, one of my clients, I believe he's got 400 or 500 vehicles on the road, called me about a driver who had an epileptic seizure. He wanted to know what to do. I'm full of opinions, so naturally I gave him mine, but then I did the smart thing and I said, have you talked to Greg? So Greg and my client got on the phone and resolved the issue. He approached it from a legal perspective and how the employer can protect himself. So these are the kind of conversations that my clients are having and that I want to open up to you to let you know, if you're a client of McMichael Insurance, you can have these conversations as well at no cost to you. Jen is going to send out a follow-up email. Greg's contact information will be there. Feel free to reach out to him. I hope to see you on future Value Beyond Insurance webinars. We do have an ongoing effort to bring these to you on a regular basis. Our next one is scheduled for May. It's a timely topic. I think we've settled on how to handle when that applicant shows up and you're not sure if it's a Donna or a Donnie or a Danielle. How do you deal with that? So I think Greg's going to go into more detail there, along with some conversations about our websites and ADA compliance, and probably even some physical plant ADA some compliant issues. So keep your eyes open for the email invite for our May event, and check out our postings on LinkedIn. If you haven't connected with us on LinkedIn, please do so. If you're on this call because a sponsor invited you to join the webinar, please say thank you to either NTMA or say thank you to Excelis IT. I wish you all a good rest of the day. God bless you, and enjoy the day. Thank you.
Hey, before everybody goes, I am going to also include in the next seminar what to do when OSHA shows up and the rights that you may or may not have in terms of supervisors, employees, and the anonymous OSHA complaints. So thank you, everybody, again, and I will rely upon my team to tell me how many winners we have, and we'll get the cards out to everybody. So thank you.
Thanks, everyone. Thanks,
Bye-bye.
Greg. Bye now.